SJC-13504, Commonwealth v. Alvin, Campbell.
Okay, Attorney Levin.
Thank you, Your Honor. Good morning. May it please the Court, Patrick Levin on behalf of Alvin Campbell. Mr. Campbell's claim in this case produces a counterintuitive result, but ultimately it's legally fairly straightforward. The force clause of General Laws, Chapter 276, Section 58A, includes only those offenses that have as an element the use, attempted use, or threatened use of physical force against the person of another.
Can we define where we are on the categorical part of it and just jump right in? So, categorical review, which we said in Escobar is all the force clause cases and the like. The example that's often used for assault and battery, if the worst assault and battery, not to quite as a punch in the face, but assault and battery can be reckless, and we have the cases, the examples where someone punches a glass window, a shard hits someone recklessly. So we say that assault and battery does not come under the force clause, right?
Yes, Your Honor.
That's where we're at. When I look at Section 22, we have, at one extreme, we have a stranger rape out of the bushes.
Yes.
Then the other extreme, which I think is where we're going to be focusing our attention to, as I see it, would be those cases involving constructive force or an incapacitated victim.
I agree.
Is that your reading as well?
Yes.
All right. So if we look at constructive force, and so we're not dealing with recklessness, we're
Right.
dealing with
Right.
the force. Isn't, even in a constructive force and incapacitated victim case, there an active penetration without consent, so it's force and against the will of the victim?
Yes.
Tell me why that doesn't satisfy force when it's forcible against the will of the victim because of the physical act of penetration.
So the answer to that question pulls back to the statutory language of Section 58A, which is the use, attempted use, or threatened use of physical force.
Right.
So in Escobar, the key statutory phrase was use of force against the person of another. In this case, it's use of physical force.
Okay, so isn't the unconsensual act of penetration an act of physical force?
So in common law terms, the answer to that question certainly is yes. At common law, force is any application of, any touching of another person is a use of force.
This isn't just any touching.
No, but at common law, that's the meaning of the word force. But this court has said that common law meaning is not what is meant by the phrase physical force.
But that's not what we're talking about, is my point, that's all. That we're not talking about just touching.
Yes, that's certainly true, Your Honor. But I guess my point is just that there's a difference between common law force, which this court has held does not qualify under Section 58A, and the definition that this court has given of the phrase physical force, as that phrase is used in that statute, is a violent force likely to cause bodily injury. And
Where did we say that, Mr. Levin?
that's in Vieira, Commonwealth versus Vieira.
Violent?
Yes, substantial or violent force capable of causing bodily injury. And it goes back to, in this court.
Why doesn't this meet the statutory definition then? I mean, you know as well as I know, as this goes along, what's one of the first things that happens in these prosecutions? You have an examination, and sometimes you look for physical evidence of the forcible rape. So how does this not meet the definition of violent force likely to cause bodily injury when you're doing this against somebody's will?
So there's two key parts of this statutory phrase, right? And one part is the physical force, and so I've tried to speak to that, what this court has defined that phrase to mean. And the other part of the statutory phrase is an offense that has as an element the use of physical force. And so what it means for an offense to have a particular fact as an element is that proof of that fact is required in order for someone to be convicted of the offense, right? And so that's what the court, when the court talks about the categorical approach, and particularly the U.S. Supreme Court tends to talk about it in terms of what is the least the least amount of conduct that is criminalized by a particular
And that would go back to the
offense.
incapacitated or constructive.
Right. And so the question is it possible to be convicted of the crime of rape without the Commonwealth having shown the use, attempted use, or threatened use of that type of force that is liable to cause a bodily injury? And so if you look to take the,
I'm sorry to interrupt you, but can you take me back to Vieira and how we came up with that?
okay,
And
so.
what were the facts in Vieira?
So Vieira is an indecent assault and battery on a child. Those are the facts of Vieira. And then if you go back one case further, you have Sione versus Commonwealth, which is the statutory rape case. And so I guess ultimately the simplest way of looking at this case is to take the example that Justice Gaziano gave of the incapacitated victim or the incompetent victim, and to compare the required elements of proof for the offense of rape of an incompetent victim with the required elements of proof for the offense of statutory rape, which in Sione this court held.
But don't you have a problem in Sione? I know you said it's dicta, right?
Yes,
When we said
yes.
rape of child with force versus rape of child. But in Sione, we also said that rape of child with force would qualify under the force charge.
Yes, that's
Right.
true, Your Honor.
Okay.
And
Rape of child with force is the same crime as Section 22, but with age discrepancies.
I agree.
So that's a problem for you in Sione, right?
Well, that whole discussion of the force elements of these two crimes in Sione is dicta. And so if you look at the holding in Sione, the holding is there is no element of force in the statutory rape offense.
And that's the holding period, and everything else you say.
That's the holding. And so you obviously, in the course of the discussion, you contrast that with other statutes that do enumerate an element of force. But you don't then go on to analyze those statutes, because those statutes aren't in front of you, to determine whether the force element of those crimes is the necessary physical force under the statute. And we know.
So twice in Sione, we actually said that the force element in a Section 22 rape would be satisfied.
Yes,
Right.
but
One by comparing it to adult crimes, and one by comparing it to rape of child with force.
yes. But as I said, there isn't any analysis of what the phrase physical force means in the statute in those cases. And so the argument that's in front of you here was not in front of you there, and the statutes that are in front of you here were not in front of you
So
there.
let's talk about
And-
the force that you're arguing, why it would not be physical force under 58A.
Yes. So to go back to the incompetent victim, and what I was going to say is if you compare the elements of the statutory rape offense with the Section 22 offense of rape of an incompetent victim, there is no material distinction.
Oh, no, there's consent. There's a huge distinction.
There is no consent in either of those cases. There is no legal consent.
Well, there's an incapability of giving consent. The
Right.
statutory rape cases that we had in Sione, we envisioned, and I forget who argued that, and we agreed, was to take the two 16-year-olds or 15-year-olds who have a consensual relationship out of the picture because it's consensual sexual intercourse. In the incapacitated victim, we have someone who's, on the dorm room bed, passed out, drunk out of their mind, who can't consent because of that. So it's against the will of the victim in one instance, and with the will of the victim in the statutory rape instance, correct?
Yes, but the fact of the matter is that the required element is not an element of force, but the non-consent element that you're talking about is satisfied by the absence of lawful consent,
Well, it's-
regardless of whether there is factual consent. And so
Correct me if I'm wrong, the force element is, there has to be some type of force and against the will. So it's part and parcel of the
yes,
same
the
thing.
separate elements, yes. So to take the against the will element, right, the absence of lawful consent, even in adult rape cases, does not necessarily imply a factual absence of consent. And so if you take a case of an incompetent victim, a mentally disabled victim, for example, an intellectually disabled victim, and we have cases like that in this Commonwealth. Commonwealth versus St. Louis is a case that I cite in my brief, where there's an intellectually disabled victim in that case who actually is the initiator of the sexual contact. And so it's equally true that a rape can be, a conviction of rape can be returned, even in a scenario where there exists factual consent if there is no ability for lawful consent.
What about the act of penetration in and of itself as satisfying force?
So I think it's clear from Sione that that can't be the case.
Well, I should qualify. You're unconsented to act of penetration.
So again, there is no distinction in terms of the required elements of the crime, because as I said, if you have that case of the intellectually disabled victim who factually consents but is legally incapable of consent, that is the same non-consensual penetration that exists in the statutory rape context.
So because we take a categorical approach to it, that is why, I mean, you're not making the argument that a non-consented physical penetration doesn't meet it. It's because we can sweep in this other category of behavior that
Right, and so,
you can't do it.
So under the categorical approach, what this court and the Supreme Court say is that the very least of the conduct that is prohibited by a given statute is the conduct that we look to, because if that is the only conduct that is required to return a conviction, then that's the conduct that the offense has as an element, which is the statutory language here. Just to circle back.
So without consent, even in the intellectually disabled person, the defendant has forced himself on the victim, correct?
Yes, I think that's true, but not in the way that this court has defined that statutory phrase. And so it's not the word force has distinct meanings in different areas of the law.
The statutory phrase is the 58A phrase.
Of physical force.
Of physical force.
Right.
Right, and I guess the
And
question I
just
have
to,
for you is we have physical force because of the act of penetration is part and parcel as well as the definition of the crime.
well, yes, so I agree with that, except to say that the act of penetration in this Commonwealth, I cite Commonwealth versus Donlin for this in my brief, that element is satisfied by evidence of any touching of the vulva or labia. And so it's equally true that, any touching of an incompetent or an unconscious person's genitalia constitutes the crime of rape. And although extremely offensive and an enormous affront to that victim's dignity, that victim's personal integrity, that is not physical force as this court has defined it under Section 58A, which requires a likelihood of bodily harm. And when you look at the cases that talk about common law force and offensive
And
battery.
the likelihood of bodily harm comes from Vieira?
I'm sorry?
That comes from Vieira, that
Well,
phrase that you
it comes
use?
from Vieira, but it traces back through Vieira to Commonwealth versus Eberhardt, Commonwealth versus Cologne out of the appeals court, which takes it from Commonwealth versus
Those are all
from
the ACC
from United
cases.
States versus Johnson. Yes.
But those are all the ACC cases,
Yes,
right?
from the
We'll-
ACC cases,
we'll use
which
which
that
uses a
statute
modified
uses.
categorical.
That statute uses identical language. So I did want to address this modified categorical approach question.
Right, but isn't there a distinction between using the modified, I know this is obviously a distinction between modified categorical. If it was modified categorical, you probably wouldn't be standing here, actually. But if you're saying the definition of force is going to be the same in the ACC situation and 58A under whether you use categorical or modified categorical.
But in the ACC context, this court has said that we can look beneath the indictment,
Right.
beneath the charged offense, to see what actually were the nature of the elements that were proved to the jury in the prior crime.
I'm just wondering
Whereas-
if we're bound by the ACC cases in the definition of force because they allow for the modified categorical.
Well, I think that the court has very expressly adopted that definition in Sioni and in Vieira. There was actually an extensive discussion of this in both of those cases where the court says this is the same language. There's no reason to think that the legislature meant it to mean anything different.
You pointed out that those cases are not this case. Sioni is not about, it doesn't have the same facts. So we were not looking at an expanded definition of force and whether or not that was the same as, ACC. Just to be clear.
Yes, of course. But the point being that this incongruity does not arise from this court's understanding of what that statutory language means. It arises from the fact that a substantial portion of the statute as enacted by the legislature has been struck down. And so you have the legislature enacts the statute that says any felony offense that has as an element the use, attempted use, or threatened use of physical force against the person of another, or any other offense that presents a substantial risk that such force may result.
But your argument is basically this was a residual clause.
Yes, and in fact,
detention.
most cases are residual clause cases. The force clause is extremely narrow. And particularly in a jurisdiction like Massachusetts, where so many offenses are common law offenses that adopt a misdemeanor common law definition of the word force. So if you take Commonwealth versus Mora, which is another ACC case out of this court, that's a robbery case. And you see the statutory language under Chapter 265, Section 19, punishes anyone who robs another by force and violence or by assault and putting in fear. This court says that is not categorically a forcible crime under the force clause because it's possible to commit it without that type of force that requires, the type of force that will cause bodily harm. Because the example in that case is a purse snatching that occurs, before the victim is even aware of it. And so that is force within the common law definition because you've touched the other person, but it's not physical force within the meaning of Section 58A, even though robbery clearly is a violent crime, a crime of force at common law. But that's not what the legislature meant. And it works in both directions, right? Just because the statute says the word force doesn't necessarily mean it qualifies under the force clause in Section 58A, but just because the statute doesn't use the word force doesn't necessarily mean it doesn't qualify. So if you take Chapter 265, Section 14 or 15, assault with intent to murder, that statute doesn't use the word force, but it clearly does have as an element the attempted use of physical force against the person of another, because the definition of an assault is an attempted use of force, and the intent to murder clearly requires it to be force of the type that is likely to result in bodily injury. And so there's nothing magic about the word force here. You have to look beneath that word and see what does the element actually require the Commonwealth to prove in the least case. If there are no more questions, I would just ask the court to reverse the single justice's order and remand the case for a new bail hearing.
Okay. Thank you very much.
Thank you.
Okay, Attorney Lewis?
Good morning. Are we still morning? Your Honor, Sarah Lewis on behalf of the Commonwealth. With me today is the trial prosecutor on the case, Assistant District Attorney Lynn Feigenbaum.
I was a bit confused by your brief when you said that the other side of the defendant was not using the categorical approach. I thought as we laid it out, or I laid it out to start, my example of the assault and battery, the punch in the face versus the window shard, and then we have rape, which at one extreme is a stranger rape, the other extreme would be constructive force incapacitated victim. I thought we go to, just like the window shard case, we go to incapacitated victim, constructive force. Isn't that true?
I would respectfully disagree insofar as the categorical approach does not look at the facts and circumstances of the case.
Right. So we go to the crime and we say, how could this be committed, basically almost in the light most favorable to the defendant?
And my understanding of the categorical approach is that we look at the elements of the offense. Here, one of the elements being the use of force. If we dive deeper into how that force is proved,
Okay, so we
that seems to go to the modified categorical approach as to looking on the face what the elements of the crime are.
I'm not so sure about that. So if we go to Sion for a second, right?
Yep.
So we have rape of child, and I'm sure Ms. Feigelbaum and actually myself have prosecuted rape of child cases where you charge rape of child because it's an egregious, they're all bad, but it's an egregious rape, but you just can't prove force. So you would charge rape of child, sometimes offensively called statutory rape, but still rape. But it also could be committed by the two consensual 15-year-olds. So that's why we look at the two 15-year-olds having consensual sex, not the father molesting the child.
And in Escobar, I think we said an offense is a predicate offense under the force clause if and only if the elements of the offense always fall within the ambit of the force clause.
Right, so I don't get your analysis about why that's modified.
So first, statutory rape doesn't have as an element the use of force. So the question in Sione, in my understanding, was to look at whether it necessarily still involves the use of physical force, because it didn't have as an element the use of force. Rape has as an element the use of force. But even if this court disagrees with the Commonwealth...
But the force in rape can be accomplished through constructive force and or an incapacitated victim, correct?
Yes, and I would suggest that those are looking to the facts, and that's looking to the facts and circumstances of the case. But even if it's
No,
not,
it's looking at whether it falls within the ambit of the use of force, the least of it.
and if that's true, then I think irrespective of the use of force element of rape, as your honors were suggesting, rape, the other elements, penetration with a non-consenting adult, also satisfies the force clause of 58A, because that necessarily involves physical force.
Because you
So I
have to
think there are,
take the crime as a totality, because just as Mr. Levin said, you can't just focus on the elements, because sometimes that element of force isn't there. We look at the against the will part of it and the act of physical penetration.
yes, and I understand that the use of force can be, this court has interpreted it as it can be satisfied by constructive force. But the penetration together with lack of consent also satisfies the force clause of 58A.
Constructive force, and I think I've heard I was looking at them this morning, there's an appeals court case where a police officer, in uniform, takes a motorist into the cruiser and says, hey, and rapes them, and the motorist female says, I didn't say anything, but I was petrified. And he's using his authority as a police officer to accomplish against her will, even though she didn't say anything and was, again, petrified and didn't. That's constructive force, correct?
Yes, and I believe you're referring to, and I might be not pronouncing it correctly, but Caracciola. And I actually think that case is very instructive here, because what the court, from my understanding, was suggesting was that the use of force element of rape would be superfluous if it wasn't interpreted as allowing for more than just physical force. Superfluous because rape, penetration with a non-consenting adult, constitutes physical force. Therefore, if we're going to add, the legislature adds this additional element of use of force, the court interpreted it as allowing more than just physical force. Constructive force, duress, threats, fear. But that doesn't take rape out of the force clause of 58A, because you have these two other elements of penetration and lack of consent.
Yeah, and this is Commonwealth versus Mayana, 103 Mass Appeals Court, 1104 recent case. Constructive force exists where the defendant's words or conduct create an intimidating environment or instills fear in the victim, compelling the victim to submit. Right, so you say that plus the element of against the will plus the element of penetration equals force.
Yes, I do.
Equals, well, does it
Physical
equal,
force.
how does it equal physical force based on the definition, I guess, in Vieira that?
And that's the other point I wanted to turn to. I disagree that the court adopted the ACC definition of physical force in Vieira. What the court said was that the force clause of 58A mirrors how violent crime or a violent offense is defined under the ACC, federal ACC, Massachusetts ACC. But it didn't go so far as to adopt the definition of physical force that the ACC adopts, or that has adopted in ACC context. But what the court did say is that physical force for the purposes of 58A does not mean, quote, the use of force so minimal as to encompass an offensive battery. And I think that's really important. To hold that rape does not qualify as a predicate offense under the force clause here would equate it then to an offensive battery and a de minimis touching. And I think we all know that that's not the case. So I would disagree that this court adopted that definition of the force clause in 58A, adopted the definition from ACC, but even if it does, rape would qualify.
Is this a question of legislative intent?
Yes. And the legislative intent of 58A is to systematically identify those who may present a danger to society and to incapacitate them before the danger may be realized. And the question in this case is a threshold question. The scheme of 58A is to identify a predicate offense. That's not going to say that the court then doesn't move on to look at the facts and circumstances of the case. The Commonwealth bears a heavy burden at the hearing, at a 58A hearing, to establish dangerousness by clear and convincing evidence. The
But
question
we're talking
here,
about the initial stage where whether you even get the hearing.
exactly, but I was raising that point to say that it's bifurcated. The question is, does an offense qualify as a predicate? And even if it does, there's still another protection for the defendant to be held pre-trial.
But yet the constitutional overlay of this, of course, is to be constitutional under Salerno in our case law, it has to be the worst of the worst, correct? The crimes that you can detain on.
And a very serious crime. It doesn't, I will say, 58A does not say make a predicate a violent crime that has as an element the use, attempted use, or threatened use of physical force. Like the ACC, it says a felony that has as an element the use, threatened use, attempted use.
So that's a distinction between the ACC and 58A.
That is a distinction.
The use of the word violent.
It is a distinction, and I think that's leads to the definition of physical force in the context of ACC. But again, rape is an extreme crime of violence. So if we do pull from the ACC.
I mean, if it's just like, but that's what some of the ACC cases say. And we said in Escobar, if you ask the person on the street, is rape a violent crime? I would think 100% of the people are going to say yes. If you said, is assault and battery a violent crime? 99 would say yes. Very few people would know, of course. You punch the shard of glass, and there's a recklessness part of it.
Right, and I think those distinctions are relevant in an assault and battery context where you're looking at, as Your Honor did in Escobar, whether it can be committed recklessly and wantonly. And I think that's different from rape, where a defendant, it can be proved through defendant intending the sexual intercourse with a non-consenting adult by force. And so you have this element of force, and irrespective of that element, you have physical force because of the penetration with a non-consenting adult.
If we decide this case in the defendant's favor, would rape of child with force be a non-detainable offense?
I would think yes, but that would be against the court statement in Seone. Very, very.
I wouldn't rely on that here, just because that wasn't what we were focused on.
And I understand. I would just point out, though, that there was a clear statement that forcible rape of a child does qualify, and there is also, as I pointed out in our brief, cases that say that forcible rape of a child can be committed through constructive force. Because,
again, you have these other elements of penetration and lack of consent, which is distinct from statutory rape involving the voluntary participation of two people. The consent is a crucial, the lack of consent in adult rape, I think, is a crucial consideration here. If your honors have no further questions, the Commonwealth will rest on its brief.